Hey y'all, welcome. It's Saray, and I am here on Legal Ray, and we're about to talk about some fun stuff today. Before we get started, I just want to let you guys know I am not a lawyer yet. Soon I will be in 2025, but I am a legal scholar, and I attend a law school here in Georgia. And basically, I'm just going to be giving you guys my personal opinions about some of the legal issues that we see in today's um, day and time. And we're going to be reacting to a lot of legal videos. And the first one is going to be pretty interesting because we're going to be reacting to someone reacting to, uh, not someone, a lawyer reacting to a well known case in today's time. And I'm going to be kind of just, he's going to break it down to you, and I'm going to break it down to you what he's breaking down to you, if that makes sense. So, yeah, y'all tune in and let's get to it.
Vice versa is also true. If the defense can do enough in one day to show the state has not proven their case beyond a reasonable doubt, coconut bowls, then it's over in their favor. So I think the medical examiner did a really good job of explaining. She wasn't my favorite witness. I didn't think she was overly compelling, but I do think she did a good job with the medicine, showing where we can see entry and exit routes. What I thought was really interesting is because she was so experienced, she was able to give testimony like we're about to watch together, where she said, in all of her experience, it is very unusual for her to be able to tell which shot came first. But this was one of those cases she was able to do so. And that's incredibly important because did the fatal shots come first from inside the car and then a staged or fake drive-by shooting? That's what the state's trying to prove here with these witnesses. So let's listen to what she said.
Okay, so if you don't know what he's referring to, so YNW Melly is on trial for killing two of his best friends, allegedly. And the whole background of the story is that the co-defendant, Bortland, originally reported that this was a drive-by shooting, that him and Melly did not, that basically that was the cover up. That this was a drive-by shooting. Melly was not responsible for killing Sack Chaser and Juvie, and that basically someone came by and drove and shot up the car. So here's the problem with this statement. The state has evidence that, let me get this correct. The state has evidence that that Bortland's statement is not true. And how do they have evidence? What evidence do they have? Well, basically, they have evidence of the shooting coming from within the car, meaning that they have the stippling and they have trajectory, which someone will testify to in a bit, and they have other forensic evidence that indicates that this was a shot in close range, close to the head. Meaning that this couldn't come from outside of the car. This definitely came from inside of the car. Now, the problem that the state still has, in my opinion, is that, okay, one, Melly never gave a statement to the police about whether it was a drive-by shooting or not. Bortland did, and Bortland is his co-defendant. They're not being tried together. So, if anything, this proves, okay, yeah, maybe it wasn't a drive-by shooting. Melly never said it was, and so you still have to prove the element of him actually doing the shooting, and this is not disproving that. Now, they are going to try to place him into the car, the back driver's passenger, no, driver's side, the back of the back seat on the driver's side. And they're going to try to say, they're going to have medical examiners or forensic scientists come in and testify that that's where the shots came from. That's why supposedly all of the fingers are pointed towards Melly and not Borland. But that's what they're referring to here.
where I can tell that the gunshot case, not even, I just had a stab wound case, but in the hundreds of cases that I've done, the thousands of cases that I've done, there are only 30 where I can tell you the order in which the shots occurred, because some were before the person passed away and some were after. And it makes sense, right? Like if you're thinking of an actual drive-by shooting, or even in the Murdoch case, they were not positive which shots came first. Now, they had some guesses based on the fact that after one shot, you'd keel over and then it would travel this way, but they were not sure and they couldn't testify to that to a reasonable degree of medical probability or medical certainty. So that's different in this case. She's saying out of thousands of cases, this is one of 3 that I actually can testify to that level as to which shots came first, and that is significant. When you have somebody with this much experience that says this is an outlier, that usually makes the jury listen up. I've had hundreds of gunshot wound cases where they're shot 15, 20, 25 times, and every single gunshot has happened. So, are they within seconds? No, but I can't tell you, is it, 5 minutes? Is it 30 minutes? There's no way for me to tell you what the time frame between gunshot wound A to B.
Now, this is important because there was a subsequent witness that testified to the timing of the shots. And she's saying, no, I can't tell you how long in between the shots were. Because, like, think about it with logic. So if you're sitting in the car and you got the driver, 2 passengers, one is in the front seat, one is in the back seat on the passenger side, and then there's Melly, supposedly, in the back seat on the left side, behind the driver. If Melly goes to shoot, I'm not even sure which one they're saying he shot first. I'm not even sure they can tell who he shot first. But let's just say he shoots the dude in the front seat first. If he's shooting the dude in the front seat, boom, close range to the head out of nowhere. Then he turns to shoot the dude beside him. Think about it, that's gonna have to be a pretty quick, occurring of events. Because if you just shot somebody, in the head in the front seat, out of nowhere, and then I'm sitting beside you, I'm gonna be like, I'm gonna react. Like, I'm not just gonna sit there and be like. So he would have had to done that very quickly. So that's another thing that they don't have to prove, but it would be good for them to prove that this was done very quickly, because it would go along with the story of them being shot in the head. Being shot in the car, not by a driver.
E is from when B and C were inflicted. Moving on to D. What about this particular mark tells you that this is an exit wound? So D is an exit wound. It's lacerated. Okay, because you have a blunt force object for projectile traveling at a very high, traveling at a great speed, and with an energy perforate the skin, and it causes a laceration. I'm going to jump ahead to give her multiple times. She kind of explained how we know which ones were the fatal shots and which ones were not. I think she explains it here just so we can get an idea and kind of frame of reference as we continue on in the evidence the state presented over the last couple of days. Do it for a cutting, just open up the side of your, they open up your ribcage to try to get your heart beating again. And there's lots of things that they will do to try to save somebody's life. Were there any events to return those instincts? In terms of the rest of the internal examination, were there any other findings that led to the death of Mr. Williams other than the gunshot wounds we talked about? No. Very well. Do you collect samples for the purpose of processing for toxicology? So, she is sure that those are the fatal wounds and no other shots were. And I guess I missed it in this explanation, but the way she explained it is, you can tell whether the heart and blood are still pumping when a shot hits. If somebody bleeds, the vascularity of what's going on with that entry wound, how that entry wound looks compared to the exit wound, how the body will bleed afterwards. And only the shots that came left to right line up with what would be consistent as a fatal shot, or somebody is living when they were shot.
So a big part of the state's evidence is that the shots to the head were the fatal shots, meaning they were the shots that killed Sack Chaser and Juvie. So this is important because they were shot multiple times. I'm assuming. I know one of them was shot at least twice. But this is important because if the fatal shot to the head was the first shot, if they got that shot first, then that's essentially saying that it's lining up with the story the state is trying to prove, is trying to paint of okay, Melly shot him in the head, killed him close range in the car, got out of the car, and staged a drive-by from the outside to make it seem like they were in a drive-by shooting. So if they're saying the first shot or the fatal shot was the first shot, then that means that the two victims were already dead during this so-called drive-by shooting, and that goes along with the story that the state is trying to paint. But like I said, there's still the element of okay, that may be the case, but you can't prove whether Millie is the shooter or not, or can you?
Not the drive-by shooting shots. Haley, hey Peter, been following you since the start of Melly's trial. Thank you so much for the breakdown of things to us non-lawyers. Haley, happy to do it. It's what makes it very interesting and fun for me to learn about how you guys feel about the trial, how you see witnesses. Because how we're going to look at these witnesses, I think is going to be interesting. Sometimes people disagree with how I see witnesses. I didn't find either of the medical examiners to be amazing witnesses. While I felt like the evidence they helped present was very beneficial, but I thought the trajectory shooter sergeant was actually a really good witness. So I want to know from you guys, do you agree or disagree on what witnesses? How do you grade these witnesses? First with the medical examiner A through F, this one, if you watch the trial, and we'll do the rest as well as we go. Bueller, Peter, what was the motive? No one will or can tell me. I do not know. Now.
So, okay, motive is not an element of a crime. The prosecution does not have to prove motive. And motive, if you don't know, motive is the purpose behind something. So the reason that this was done. What is the reason that Millie would go into the car? That if you've seen the video of them getting to the car, they're all but like there was you could see no animosity, there was no tension that you could see off of the video. So what happened from that point to this murder that caused Millie to shoot two of his best friends, I mean, horrifically in the head, basically shot the head off. So like you would think most times that there would be a motive behind it. Like most people aren't just riding around with their bestie one day and say, "Hey, boom, dead." So that's what people are wondering. Like the state has not proven any motive, although they don't have to. It always juries like to know what a motive. It's like we're people. Jury are people. So they want to know what caused this person to do such a horrific crime. Now, the prosecution is trying to offer up the motive of Melly had just joined the blood gang or something, and this was basically a way to show his loyalty. But after that testimony about the gang and all of that situation, like to me, it seemed as if Melly had still, even after the crime, he still hadn't even joined that set. Now, it's a difference between, I guess, the gang and a set. Don't get me into it, but they're saying that he was a part of a certain set, and joining that set, this was like a way to show his loyalty. Like, come on, that's a very weak motive. These were his best friends for years, and I'm not trying to like be stereotypical, but more than likely, if Millie was a part of a gang, that then these two victims may have been part of the game, or either at least to the least, not to the least, at least they probably at the minimum knew about the gang activity. So what? Why would a gang want you to turn on your two friends like that? I don't know. It seems weak to me.
Important to point out, the state does not have to prove motive, but jurors like to have a motive, and without a motive, that case becomes a lot more difficult for the state. But
Yep.
The state did quite a few things here that may not be the most probative things in the world, but I think jurors really, really like demonstrative aids that we're going to get to in a little bit that the trajectory expert did a good job of explaining, in my opinion. All right, let's see where we go here. So she was confident and clear that the fatal shots came from inside the car and from the back left seat, based on how the entry and exit wounds came, and that the shots from the drive-by were after the fact, because you could tell the blood was no longer pumping. On cross, did a good job of picking her apart a little bit, saying they shaved the victim's head. You could have found something from gunshot residue. To me, while this cross sounded decent, it didn't really poke a lot of holes in her testimony. She can't determine how far away the shooters are, obviously. She can't determine how many shooters there are, obviously. That's not what she's meant to do. And there was a mistake on the autopsy because they missed a shot in the leg. That's bad. That makes you look incompetent. That goes with the opening that this was an incompetent investigation. Everybody was incompetent throughout. More on that later. But again, does it do anything to poke any holes in her testimony that these are where the shots came from and these were the fatal shots, not the staged drive-by shooting, which is the state was able to use that staged drive-by shooting in their questions. I would have objected to that as counsel testifying. I think they can do the alleged drive-by shooting now.
Okay, so what he's talking about is the state prosecutor. During a line of questioning, she must have asked something along those lines of, did that match up with the staged drive-by? Does that match up with a drive-by shooting being staged or the staged drive-by shooting? I'm not quite sure on the particulars, but that is not allowed because that's counsel testifying. It has not been proven that the drive-by was staged. Only so far at this point it has been alleged that it's a staged drive-by. So you can't ask a question as far as you can't say that in your questioning. She should have said alleged drive-by shooting or alleged staged drive-by shooting. And the defense attorney could have objected to it for counsel testifying, but he must have missed it.
On stage. The stage is telling the jury that it's staged, which hasn't been proven yet. Okay, then we heard from the associate medical examiner, who again talked about how it entered into the left cheek of the backseat victim and out of the right side, coming from obviously somebody sitting next to him. Just as an example, we'll see real quick how they use this demonstrative aid in case anybody wasn't watching.
Using a demonstrative to assist in explaining or illustrating her testimony. Remember that the testimony of the witness is the evidence. The demonstrative is not the evidence. It's not the considered.
Multiple witnesses use this demonstrative aid. I'm just going to play a minute of it here so you can see what it looked like in case you didn't watch the trial, to give the jury something to see and look at, to see the entry and exit with what it would have looked like.
There's evidence. And unless you can't receive evidence, it does not go back to the jury room for your deliberation.
So your shatter on the center phone record head that you have in front of you, and you show the mark that you place on that would be equivalent to the mark A on Christopher Thomas's face. So the entrance would be approximately right here on the sheet. And in terms of where the signal going, right, you said that the impact or the terminal location of the voice was, where would that be on that? So in order to accurately hit that, you have to open the ring, and if I don't do that, then approximately right here, then on the inside. And so you just try to show that to the jury and point on that.
All right, y'all, welcome back. I know I probably look a little different than I looked when I first started this video, but that's because one, I got a new computer, and the quality is so much better. Ignore my eyelashes because I know one is lopsided. Well, one is not even full, the other one is, and this was already my lazy eye, so it makes it look no better. Anyway, on top of that, I got a new hairdo, so Alright, so yeah, we're gonna jump right back into it, y'all. So we are about one-fourth of the way through this testimony, or not this testimony, but this trial day. I think this is day 9 and 10. This is just a reaction video that Peter is going to do. So we're gonna react to what he reacts to. Let's do it.
And then here's her testimony about how you know when somebody's alive, when a trajectory enters, and the difference between when they're not.
So it's upside down and turned around.
Okay.
So if you were to cut this open and hollow it out, you would just literally flip it back in like that.
Okay. So what are we looking at in this photo here?
That is the base of the skull.
And what has been done to get access to this part of the skull?
So I inserted a rod to show that the trajectory from the injury from the left cheek went all the way through and crossed into the right side of the cranial occipital.
And in terms of, is there evidence of hemorrhage along this swing track?
Yes.
Would you have an opinion as to if the individual was alive when the heart was beating when this swing was inflicted?
Yes.
And what would that be?
Can you say that again? I'm sorry.
What would your opinion be?
So, my opinion is that at the time that this gunshot wound was inflicted, because of all the hemorrhage to the base of the brain, that this individual was alive.
Okay. So the lack of hemorrhaging would indicate he was not alive. So this is how they explained it kind of over and over again and what would be indicative of this. Thank you, Brianna. Okay, then we get to the cross of this witness. And
now, y'all, I love Melly's lawyers. Like, they are on it, okay? Nothing is getting past them. Nothing is going to be, they're not taking a little brush on the shoulder. They're going to come at you full throttle. So if you get up there as an expert for the state's case, you better know what the hell you're talking about. Because these people are not playing games.
They tried to let her get into some analysis of the trajectory. They blocked some of it, allowed some of it. I didn't think that was very helpful, but we get that with the next witness. The first thing the defense attorney kind of hits her on is her lack of experience at the time, how she was only brought out to the scene because this was such an interesting case. But then I felt like the end of his cross summarized what the state wanted this witness to prove. Maybe they have a plan, but I wanted you all to watch it and just tell me if you felt like this was as bad for the defense as I did while I was watching it.
Okay, so basically, like, he's saying that he felt like the end of the cross-examination, which is Melly's lawyers. Okay, so for each witness, you have a direct examination, which is what that was. That's the state. They get up there, they bring their witnesses, they ask them direct questions. They cannot lead the witness, so the witness testifies their own story. Now, cross-examination is the complete opposite. You can lead the witness, you can, impeach the witness, or whatever the case may be, and that is done by the opposing counsel. So this cross-examination, what he's saying is he didn't feel like it was as effective as it should have been for Melly's lawyer, or maybe he felt like they went too overboard with it. I haven't heard it yet, so let's just jump into it.
And I was just like, that's like almost how the state should have tried to summarize her testimony, and now the defense just did it, which obviously is not great for the defense.
As a learning experience, because in all of her career,
this was the question about you were just out there as a learning experience, not because you were an expert of some sort.
It's very unusual to determine what is shot, the first shot to an individual versus the second, third, fourth, or fifth shot, correct?
Correct.
And she took you out there to show you that the first shot on the individual you did the autopsy was the fatal shot to the head, I think you said, or the neck, cheek, excuse me, was the fatal shot, correct?
Yes.
Which means that the person, when the other shots occurred, was dead, correct?
Can you repeat that again, please?
The first shot to the cheek was the fatal shot.
Yes.
Correct?
Yes.
The other shots that you described, and we saw photographs of, occurred after the death because there was no bleeding or hemorrhage, correct?
Correct.
And that was the reason why Dr. McDougall took you out there, because in her career, it was so unusual to say, this is shot number one, the first shot that occurred, right?
Yes.
I don't know.
That's it.
Bosses say I'm finished.
Bosses say I'm finished, he says. So that was the end of his cross. The reason they brought you out is it was a learning experience, right? So unusual that you could tell that this was the kill shot because it had hemorrhaging. And the later shots did not have hemorrhaging, therefore they weren't the kill shot, right? Isn't that right? Yes. It's literally a summary of her testimony of what the state is trying to prove. And I feel like his questions just kind of drove that home personally. I wonder if the defense may say his head was turned around, or did the same bullet get lodged in the side of the car? Additionally, Christina said, what if he was ducking and turning during the drive-by? Could that be the reason why the entry-exit wounds are this way? The trajectory expert absolutely says no. Based on how the wounds were, the perfect circle would have to come this. if you're moving all around. Also, the bullets go end over end sometimes in a drive-by after they go through the car, which is exactly what it looks like with the entry and exit points of the projectiles into the car. So the trajectory expert actually takes out a lot of these scenarios, but the defense attorney does say, well, what if he's holding it like this? What if he's standing back like this? A lot of similarities to Murdoch. But I think this expert was incredibly strong in standing his ground and explaining why none of that matters in this case or is true in this case, because of how the measurements are, because of the entry and exit wounds, because of where they found bullets in the car afterwards, which we are going to go through here as we talk through his testimony. Troy Lynn, I go back and forth with my opinion. So usually, legally speaking, if you're going back and forth on your opinion, you should be at not.
Yeah, so if you're going back and forth, this is a very good point. If you're going back and forth with your opinion, that means that the state has not proved their case beyond a reasonable doubt. So if you're like, well, yeah, that sounds like he could have done it, but then you're like, well, it just doesn't sit right with me, da 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 da, this may not have happened, this could have happened, da da da. Well, technically, you should be at a not guilty verdict. So if the case was to be rested upon the state was to rest their case today with all the evidence that they provided, and the defense says we rest as well, they don't even put up any evidence, and you're going back and forth with your opinion, your verdict will be not guilty. It should be not guilty. You must be convinced beyond a reasonable doubt that the defendant has done what the state has alleged him to do. And if you are not convinced by the evidence that has been shown to you at trial that the defendant has done the alleged crimes beyond a reasonable doubt, if there's any slither of doubt, then you must have a verdict of not guilty.
Not guilty, because the state has not in a resounding way proved this case beyond a reasonable doubt. So if this is how you're feeling, you should vote not guilty. I'm not telling you what to do. I'm just saying legally this is how we would explain that burden beyond a reasonable doubt. ESL, what made today good for the state? So far, we've gone through the
So I think this day is good for the state because, one, the medical testimony about that the first shot was the fatal shot, which means the shot to the cheek, I think it was for one victim, and the shot to the head for the other victim, those were the fatal shots. And the fact that the other shots, the wounds in their bodies were not even bleeding, those that means that it's not a fatal shot. So that means that the victim was already dead at the time of the shot. So that was a great piece of evidence for the state, because that means that the drive-by situation or drive-by story, it doesn't add up, okay? Because another piece of evidence that they had to corroborate this was that the shot to the cheek and the shot to the head or whatever, the first fatal shot, the first shot in the fatal shot were at close range. They had stippling, they had burn marks, which means like the gun was right there. There's no way that could have happened with a drive-by. Now, they have not ruled out that maybe, the drive-by people came over or somebody came over and shot them close range, came through the car, but they have not proved it that Melly was the one that did the shooting yet. But they have proved that this was not a drive-by. I can attest to that.
Medical examiner's testimony, and they have stated the shots coming from this side were the fatal shots. None of the shots coming from this side were they alive when it happened. Okay, that's point number one. So the drive-by did not cause the murder. I'm not saying it didn't happen, but it did not cause the murder. That's the first thing they've proven. That's important since Cortland Henry, who was in the car, one of the two people who didn't get shot in the drive-by, and that's what he said. Is he going to flip on Melly? Well, that would be bad, but they're proving what he said was a lie. Belinda, sorry if it's already been discussed, but any chance Melly takes the stand? I'm just finding it hard to piece together it all together.
I 9 times out of 10, put my money on that Melly will not take the stand. One being, if you have been watching Melly during this trial, you know that Melly, he has some issues. And I don't know whether they're mental issues, whether he's just kind of immature, or what the case may be, but he's not ready to take the stand by any means. Because when you take the stand as the defendant, which you do not have to, you have the right to not take the stand. If you take the stand as a defendant, you are opening yourself up to cross examination by the state, and they will be prepared to tear you and rip you apart to pieces. So say if you have a propensity to have a lot of anger, or you get angry easy, they're gonna pick apart at you just for you to show your true colors in front of the jurors, and then that makes it more. That makes the jury think, oh, this person does. Look how easily this person got pissed off. I'm sure they do have the capability to murder their two best friends in cold blood. But I do not see Melly taking the stand at all.
Together, it might help to hear him. Of course, there's always a chance. I would be surprised if he did. Christina, maybe they have experts showing that you can't tell, or showing that this could happen in a drive-by. We'll see. They don't have to prove the drive.
So they don't, like what he was just going to say, they don't have to prove the drive-by. They're talking about the defense, aka Melly's lawyers. They don't have to prove that the drive-by happened. It doesn't matter. At the end of the day, it don't even matter if the drive-by happened. That's just what Bortland said. So the state is trying to say, well, we know that this didn't happen. We know it was a shot at close range. They don't have to prove that the drive-by happened. It would help if they could prove that the drive-by happened, but they don't have to. They just have to prove, or actually, they don't have to prove anything. The defense does not carry the burden of proof. But they just want to point the fingers away from Melly. That's all they want to do.
Drive-by. If you notice, they also have, like, demonstratives, and let's get to that now.
All right, y'all, so we're going to end it right here for the first video. You know, this is gonna be a long trial, and we're just gonna have to be prepared for it, because I think it's gonna go well into August. It was supposed to be mid-July, but I don't think it's gonna end that soon, because the state has not raised their case. They will not resume their case until Monday, and then after that, the defense has to go and do their case in chief, which who knows how long that's going to take. So there's no telling how long we'll be here waiting on the verdict. But as of right now, I'm sitting at not guilty. The prosecution has not proved beyond a reasonable doubt to me that it was Melly that committed these acts, but they still have a while to go, and we will see. Y'all check back in, and I will be trying to post more regularly. That word always tripped me up, like it's insane. But anyway, so follow me on Instagram at Big Play Ray. That's BIGPLAYRE, and follow me on Twitter at Big Play Ray as well. And I will catch you guys later. Thank you for watching.